It is my privilege to now introduce to our audience our distinguished guest for today. Justice Dr. Emmanuel Ugirashebuja has a wide experience from being an international judge, practitioner, and international law scholar, and as a result of which he is well equipped to contribute to the fulfillment of the mission of the International Court of Justice. He has finished his PhD in law from the University of Edinburgh and his LLM from the same university in public international law and international relations, international economic law, and international environmental law, after receiving his law degree from the University of Rwanda. He is the presiding judge of the East African Court of Justice Appellate Division, judges of the East African Court of Justice, President of the East African Court of Justice Arbitration Tribunal, Chair of the East African Court Rules Committee, member of the East African Magistrates and Judges Association, member of the Interim Government Committee of the Global Judicial Institute on the Environment. He also acted in the position of member of the Rwandan Superior Council of Judiciary until 2013 and Rwandan Supreme Council of Prosecution. He was also the Dean of the Faculty of National Law University of Rwanda, which is now the University of Rwanda, from 2009 to 2014. He was a professor of public international law and international organizations, environmental law, international economic, trade, and financial law at the University of Rwanda from 2008 to 2014. So as a accomplished and distinguished academician as well as a practitioner, we are honored to have you as our distinguished guest addressing our students today, sir.
Thank you very much. The director of Symbiosis Law School, Dr. Shashkala Gurpur. It gives me a great pleasure to be invited to give this lecture on this important topic of the principles of environmental rule of law and how law courts have applied them. I wish to commend the leadership of Symbiosis Law School for the stewardship in the debate on diverse subjects of law relevant to the 21st century. Distinguished professors and young students, it is scarcely debatable in this time and age that the anthropogenic stresses on the environment are now causing unprecedented transgression of planetary boundaries manifested by climate change, loss of biodiversity, depletion of natural resources, and other environmental degradations. It is also equally indisputable that humanity exists within nature and that all life depends on the integrity of the biosphere and the interdependence of the ecological systems. Earth life-giving systems are under unprecedented stress. When you read books such as the one published by Stephen W. et al., The Trajectory of Anthropocene, The Great Acceleration, we have transgressed at least 4 planetary boundaries out of 9, those of climate change, land conversion, nitrogen and phosphorus loading, and biodiversity loss. The concentration of carbon dioxide in the atmosphere now exceeds 350 parts per million. It is over 400 parts per million and still rising, leading to hotter, drier, and more hostile climate. Synthetic fertilizers containing nitrogen and phosphorus are being added to Earth's soils more than twice their safe levels. This has led to the collapse of aquatic life in many lakes, rivers, and oceans. Only 62% of the land that could be forested still stands as forest, and it continues to shrink, reducing Earth's capacity to act as a carbon sink. Biodiversity loss is severe. Species extinction occurs at least 10 times faster than the planetary boundary. Since 1970, the number of mammals, birds, reptiles, amphibians, and fish worldwide has fallen by half. This is according to the World Wildlife Forum report. This is a stark picture of humanity and planetary home. There are tipping points which we are still pushing on, and I don't know how far we are going to push this on to our detriment. This wanton destruction of environment contributes to an insecure, conflict-prone, and unjust place for humanity. So the vital question relevant to this presentation is, what role does or can the judiciary play in the protection of the environment, thereby ensuring a safe and just space for humanity? It has been uttered time and again that judiciaries have neither the sword of the executive nor the purse of the legislature, but merely judgment. The role of the judiciary is limited to the application of the law to cases brought before the courts. The important question to muse here then is, what can judges do to positively impact on the functioning of humanity life support systems in the light of the above limitations that we see that courts only deal with cases which are brought before them? And like obviously you have the mandate similar to the green courts in India, where courts can begin cases suo motu, but this is exceptional. Distinguished listeners, a good starting point is that the judges should abide by the principles of rule of law. But what does the concept of rule of law here mean? Lord Bingham's seminal work on the rule of law in his book entitled The Rule of Law exposed that the rule of law is not, as is often regarded, a vague concept. He defines the rule of law succinctly as such, and I quote, all persons and authorities, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future and publicly administered in court, end of quote. Lord Bingham supplements this definition with 8 ingredients of the rule of law, which are practically conceivable and very specific. The ingredients are, the first one is that law be accessible, clear, and predictable. Number 2, that matters are decided by law and not normally by discretion. Number 3, that there is equality before the law. Number 4, that power be exercised lawfully, fairly, and reasonably. Number 5, that human rights are protected. Number 6, that disputes are resolved without undue cost or delay. Number 7, that trials be fair. And lastly, that the state complies with its obligations in international law as well as national law. On a practical point of view, let me illustrate to you how environmental cases come before courts. The first way that environmental cases come before courts is through constitutional rights litigation. An increase in number of constitutions have an explicit right of environment. There are quite a number of those constitutions. I could name a lot of them, but this will take a lot of time, but it's a number, especially those in the Commonwealth countries. Other constitutions have provisions which have an implied right to a clean environment that has been inferred to. And further, assuming enforceability and justiciability, environmental concerns have been presented in fundamental rights. Due to time limitations, I will deal with cases where environmental rights have been extrapolated from existing human rights. One of the landmark cases that I assume that you all know is the Atakoya versus the Union of India, where the court held that the right to sweet water, which is unpolluted water, attributes of the right to life, for these are the basic elements which sustain life itself. This was the right to sweet water was extrapolated from Article 21 of the Indian Constitution. In another similar case, which is the Social and Economic Rights Action Center and the Center for Economic and Social Rights versus Nigeria, a case which is commonly referred to as the Ogoniland case, which was brought before the African Court on Human and People's Rights. The African Court on Human and People's Rights has a human rights jurisdiction over African countries, including most of the African Commonwealth countries. It held the view that if environment is degraded by pollution and it affects the quality of life and safety of life protected by such rights as the right to life, the right to health, the right to satisfactory living conditions, then those rights themselves are breached. Thus, the right to a clean environment can be extrapolated from existing rights. This is what these two courts concluded. That's the High Court in India in the Atakwea case, as well as the African Court on Human and People's Rights here in Africa. Thus, the conclusion of this court is that the right to clean environment can be extrapolated from existing rights. No one can capture the nexus of human rights and environment better than Judge Weramantry of the International Court of Justice, who in a separate opinion in the Gabchikovo-Nagimaros project case, in that case took place in 1997, the judgment was delivered in 1997. Judge Weramantry opined that, and I quote him, that the protection of the environment is likewise a vital part of contemporary human rights doctrine, for it is a sine qua non for numerous human rights such as the right to health and the right to life itself. It is scarcely necessary to elaborate on this, as damage to environment can impair and undermine the human rights spoken of in the Universal Declaration and other human rights instruments. End of quote of that opinion by Judge Weramantry. So the view espoused here is that environment and fundamental human rights are intertwined, and decoupling fundamental rights from environmental law is simply unrealistic and will not be in the best interest of protecting the fundamental rights we deeply cherish as a society. So what is the second way that cases come before court? Well, environmental cases. We've just talked of constitutional rights litigation. The second way is action in torts. This is the most common and traditional way that environmental cases have been brought to courts, especially in common law jurisdictions. Actions in tort law generally include nuisance, negligence, and trespass. In actions in torts, parties generally seek damage or injunctions to stop particular actions which specifically affect them and by extension degrade the environment. Historically, standing rules in actions in torts have tended to limit access to courts unless plaintiff can show a property of financial interest. By way of example, nuisance has generally been defined in a number of cases at common law as an indirect interference with a person's land or enjoyment of land because of noise, smell, air pollution, or water pollution. And public nuisance has been defined as an activity which materially affects the reasonable comfort and convenience of the public. The third way that cases find their way in the courts is actions challenging government action. This includes actions challenging government actions as well as inactions or delay. A number of legal issues unique to this type of litigation include the standard of review, the amount of deference given to a court in reviewing the decisions of a government and its agencies. For example, environmental agencies. How far can court review the decisions of government and agencies? Over years, courts have adopted a systematic balance analysis, which includes a high standard of consideration of environmental factors, a standard which must be rigorously enforced by reviewing courts. Let's take an example of a very recent case. I think it's a 2019 case, which took place in Kenya. It's referred to as Save Lamu and Others versus the National Environmental Management Authority and Amu Power Company Limited. This is commonly referred to as the Lamu coal plant case. This case referred to public participation as the oxygen by which the environmental impact assessment study and report are given life. The court was of the view that there should be a strict adherence to environmental impact assessment regulations, thus refusing to accept a checkbox approach to public participation. It emphasized the importance of climate change assessment in environmental impact assessments and found that its omission in the coal plant environmental impact assessment study made the report inadequate and incomplete. It focused on the omission of the environmental impact assessment and the mitigation measures. This case further focused on the role of the National Environmental Management Authority of Kenya in ensuring that effective public participation was undertaken, which includes ensuring that sufficient information is provided to the people who are likely to be directly affected. And lastly, the court emphasized the importance of strategic environmental assessment, particularly when considering other alternative locations for the project site at a policy level. The second legal issue that you look at when you're challenging actions of the state is the scope of the review. This involves the extent of judicial review of government in environmental matters. Finally, another important legal aspect that is looked into is the time frame of review. In other words, the statutory time limitations. Most of these issues are provided for either broadly or restrictively in legislations or treaties. The fourth way in which environmental cases find their way in courts is through criminal prosecutions. Criminal prosecutions maximize deterrence message. Remedies often include imprisonment or hefty fines. Standard of proof is beyond reasonable doubt, and it's more demanding than the civil standards. You find these cases mostly in courts in Africa, where they are dealing with illegal sale of trophies or endangered species, especially in Tanzania, where I live, in the domestic courts of Tanzania. Distinguished listeners, in dealing with environmental matters, courts have been faced with the following procedural quandaries. The first is access to court. The question that courts do face is standing. What rules are there for standing? Are they restrictive or broad? Is public interest litigation or actio popularis or class action permitted? These are questions that judges have to answer when dealing with environmental cases. The other question relevant to standing is, are there financial and technical barriers to access to the courts? For example, is the court at liberty to invite experts or to admit friends of the court who specialize in environmental matters? Finally, is there legal aid, technical assistance with evidence? So these are questions which are answered either in the legislation or maybe through the development of the jurisprudence of a given country. Historically, standing rules have tended to limit access to courts unless the plaintiff can show a property or financial interest. However, of recent, increasingly, the right of the public to participate in environmental matters is viewed as a fundamental notion of justice and essential to the rule of law. Principle 10 of the 1992 Rio Declaration on Environment and Development seeks to ensure that every person has access to information, can participate in the decision-making process, and has access to justice in environmental matters, with the aim of safeguarding the right to a healthy and sustainable environment for present and future generations. Courts, especially in Commonwealth countries, have over time tended to be liberal when it comes to standing in environmental matters, even where the law is silent. I can give you examples. Let's take the example of the Environmental Action Network Limited versus the Attorney General of Uganda and the National Environmental Management Authority of Uganda. The Environmental Action Network sued the government seeking protections from smoking in public places. The Environmental Action Network contended that such measures were required for the general good of public health in Uganda and to enforce the right to a clean and healthy environment and the right to life. The Honorable Principal Judge, Mr. Justice J.H. Nabgowa in this case, as he was then, of the High Court of Uganda, held that Article 50 of the Ugandan Constitution did allow public interest litigation by the plaintiff, given that the interest of public rights should transcend procedural technicalities. In another case, the R versus Her Majesty's Inspectorate of Pollution, Greenpeace Limited, number 2 of 1994, it was held by the High Court in the United Kingdom that nonetheless, the applicant had sufficient interest in the issues raised for it to be granted local standing. Its supporters may not have an effective opportunity to bring an action individually, and it was entirely appropriate that an established body with genuine interest in the issue should do so on behalf of its members. So the cases are bound in the Commonwealth courts, where they've taken a liberal stand when it comes to the question of standing. On the other hand, there are certain countries and courts in those countries which have been extremely restrictive when it comes to the question of standing. I can give you an example of Nigeria. Even though a common law country in tradition, it has consistently taken the stand that a litigant cannot sue unless he or she can show that his or her rights are in harm. The interpretation of local standing before the courts, as I said, in most common law jurisdiction is liberal. The Nigeria stance is a bit an exception. And you can see this in quite a number of cases. And I will share with you my paper so that you can look at the cases that I refer to. Of interest, and this is a very recent phenomenon, certain features such as rivers have been granted legal standing. Rivers around the world, as you all know, have been desecrated in every way. Now the Ganges and New Zealand's Wanganui rivers have legal standing in themselves, and this will protect their rights. Several geographically distant but related events have recently signaled a dramatic mind shift in humanity's troubled relationship with nature. First, the New Zealand Parliament passed an act which is referred to as Te Awa Tupua Act, giving the Wanganui River and ecosystem a legal standing in its own right, guaranteeing its well-being and health. And you all know that the High Court in India ruled that the Ganges and Yamuna rivers and their related ecosystems have the status of a legal person with all corresponding rights and duties and liabilities in order to preserve and conserve them. The New Zealand broad approach towards standing, giving certain features legal standing, may prove more effective in the long run by granting natural entities personhood, one by one, and assigning them specific guardians. Over time, New Zealand, as well as the approach taken by the High Court of India, could drastically change an ossified legal system that still sees oceans, mountains, and forests primarily as property, guaranteeing nature its day in court. Another important procedural issues that courts have to deal with is the question of forum non-convenience. In law, the term forum non-convenience refers to the discretionary power of a court to not hear a case that may be more appropriately or more conveniently heard in another court. The exercise of forum non-convenience results in the dismissal of the case, but does not prevent the plaintiff from filing the case in a different case, usually the one that the original court recommends. Let me give you an example of a very landmark case. It's a landmark case which I'm going to refer to, and it's the Reunited Union Carbide Corporation gas plant disaster, which was brought before the Southern District of the New York State in 1986. The origin of the case goes back almost half a century ago, when construction of a pesticide plant began in the lakeside town of Bhopal in the Indian state of Madhya Pradesh. The American-owned Union Carbide Corporation, UCC, within the thriving chemical industry, focused its attention on the Indian subcontinent. Irregularities culminated in the disaster on the night of the 3rd December 1984, when a toxic gas leak from the tank E610 in the methyl isocyanate plant got out of control. The deadly chemical cloud was quickly blown by the wind to the densely populated neighborhood next to the railway station. The controversy as to the exact number of the deaths that occurred that night still continues today. And although the UCC acknowledges 3,800 deaths, Victims Association and impartial investigators estimate that over 8,000 deaths and at least 150,000 injuries occurred. Forum non-convenience was applied in the Southern District Court of New York, and in the end, the SDNY courts decided that the Indian courts was considered more adequate for trying the case, thereby avoiding all the evidence that was maintained by Professor Galanta about the main reasons why the case should be entertained by the Southern District of New York. However, forum non-convenience is being considered differently in Europe nowadays. In the recent case of Lungoa versus the Vedanta resource case, which is a case from which was instituted by certain casualties of an investment in India. Both the High Court and Court of Appeal of the United Kingdom grappled with the question of the appropriate forum to deal with a case involving 1,826 Zambian nationals who were the claimants against the Zambia-based Konkola Copper Mines PLC and its London-based parent Vendetta Resource PLC. The claimants commenced proceedings in the United Kingdom, alleging personal injury and damage of property, loss of income and loss of amenity, and enjoyment of land arising out of the alleged pollution and environmental damage caused by the disposal of tailings and other effluent of Nachanga copper mine from 2005 to 2015 into a neighboring river called the Kafua River and the adjacent waterways. The claimants pleaded that they relied on the waterways as their primary source of clean water for drinking, bathing, cooking, cleaning, and other domestic recreational purposes, and that the waterways are used to irrigate crops, sustain livestock, and as a source of fresh fish. From the onset, Vendetta and KCM challenged the jurisdiction of the United Kingdom courts on the basis of forum non-convenience, and they argued that the claims against Vendetta were launched illegitimately, merely as a hook to obtain the English jurisdiction of a KCM. On their side, the claimants argued that Article 4 of the recast Brussels regulations, these are the EU regulations on jurisdiction, provide that a clear and unqualified right to sue a United Kingdom domiciled company in the United Kingdom, and that Article 4 allows for no discretion or disqualification to that simple proposition. The claimants relied on a very famous case, which is the Owusu versus the Jackson case, which is a decision of the which is a decision of the European Court of Justice, which plainly made it clear that the doctrine of forum non-convenience has no role to play in the European area, in the European Union area, and that the Brussels Convention precludes a court of a contracting state from declining the jurisdictions conferred on it by Article 4 on the ground that a court of a non-contracting state would be a more appropriate forum. So the doctrine of forum non-convenience has been set aside, at least for the area of the European Union. The Court of Appeal of the United Kingdom agreed with Judge Carlson of the High Court of the United Kingdom and dismissed the Vendatta's jurisdiction appeal, holding that the European Union laws impose mandatory jurisdiction on the English courts for claims against any English company which has invested in other third parties. In other words, forum non-convenience cannot be used as a jurisdiction bar in English courts as long as they are bound by the European Union law and the jurisdiction of the European Court of Justice. Distinguished participants to this guest lecture, allow me to now discuss some of the recent emerging principles in the resolution of environmental disputes. The first principle that has emerged over the very recent times is the principle of in dubio pro natura. This principle is found in the 2016 IUCN World Declaration on the Environmental Rule of Law, which espouses the idea that in cases of doubt in environmental matters, that doubt should be resolved in a way most likely to favor the protection and the conservation of the environment, with preferences given to alternatives that are least harmful to the environment. In a case which this court, the court that I serve in, the East African Court of Justice, dealt with, that's the African Network for Animal Welfare versus the Attorney General of the United Republic of Tanzania. This case is commonly known as the Serengeti Case. Just to give you a brief overview of the case, the United Republic of Tanzania wanted to build a superhighway in the Serengeti reserved area, which is one of the reserved areas with a lot of species of animals and as well of flora and fauna. The animal network for the African Network for Animal Welfare challenged this case before the court. It came before the first instance of this court and later on was appealed in this case. And the appellate division, which I serve in, when answering the question of whether the case was ripe, because what the the African Network of Animal Welfare was challenging was a planned activity of building this road. And Tanzania was arguing that you cannot challenge an idea which has not been put in place. And the appellate division, which I serve in, was of the view that notwithstanding the doctrine of mootness, the trial court did not err in granting an injunction to restrain the United Republic of Tanzania from ever implementing its proposal to construct the Serengeti superhighway as an initial plan. In our view, the grant of the injunction was proper and justified, given the imminent risk of irreversible damage inherent in any attempt to implement the plan of building the road, even though the plan had not come into fruition. In other words, even though the threshold of an action of a state had not been attained, United Republic of Tanzania was restrained from ever implementing that proposal to construct the Serengeti superhighway as initially planned. Just recently in Pakistan, the Lahore High Court, just recently in Pakistan, the Lahore High Court relied on the principle of in dubio pro natura in the Maple Leaf Cement Factory versus the Environmental Protection Agency. Chief Justice Saeed Mansour Al-Shah, who is also one of the board members of the Global Judicial Institute on the Environment, as I am, cited Principle 5 of the World Declaration on the Environmental Rule of Law, and I cite him what he said in this judgment. He provided as follows, he opined as follows: another emerging environmental principle, perhaps more appropriate in this case, declared as Principle 5 of the IUCN World Declaration of the Environmental Rule of Law, is in dubio pro natura, i.e., in cases of doubt, all matters before courts, administrative agencies, and other decision makers should be resolved in a way most likely to favor the protection and conservation of the environment, with preference to be given to alternatives that are least harmful to the environment. Actions should not be undertaken where the potential adverse impacts on the environment are disproportionate or excessive in relation to the benefits derived therefrom. In that case, there was to be a survey of the salt range in Punjab in order to delineate positive and negative areas for the grant of mining concessions. Although the project of the petitioner cement company was located in the salt range, it was not yet known whether it might or might not fall within a negative area. The court held that taking a precautionary approach and relying on the principle of in dubio pro natura, as it is uncertain that what the survey of the salt range might hold, the courts must favor environmental protection. This principle of in dubio pro natura is closely linked to another well-known principle of precautionary. In the appeals decision in one of the two lawsuits filed by the San Joaquin Valley Irrigation Districts, that's in the Southern California, and the judge in this case, Judge Richard Tolman, wrote the opinion and say that he wrote the opinion that even though the best scientific data was not available, you can always deal with science, which is not perfect, and this should be done in favor of the environment. The second important principle that has emerged over the course of years of determining environmental rule of law cases before courts is the principle of ecological function of property. This principle means that any natural or legal persons or group of people in possession or in control of land or other resources have the duty to maintain the essential ecological functions associated with those resources and refrain from activities that would impair would impair such functions. Legal obligations to restore ecological conditions of land, water, or other resources are binding on all owners, occupiers, and users of a site, and liability is not terminated by the transfer of use or title to others. Just to give the context of this principle, I may cite one of the cases from Uganda again. This case is referred to as the Iniacana versus the National Environmental Management Authority of Uganda. This case presented an important issue pertaining to the protection of the environment, where it conflicts with individual property rights in the area of conservation of wetlands, which are a source of fresh water rivers in Uganda. The court characterized the wetland as having immense ecological and economic importance, not only to the city, but also to Uganda as a country and the African region, such as it drains in the Lake Victoria. The court concluded that even though property rights were protected, the use of such property should be regulated for purposes of promoting and protecting the environment for the common good, which is referred to as the public interest good. The third emerging principle is the polluter pays and internalization of external environmental costs. The Privy Council noted that the aspects of polluter pays principle in Fishermen Friends of the Sea versus the Minister of Planning, Housing and the Environment, the Privy Council noted that it must be understood that as requiring the persons who causes the pollution, and that person alone has to bear not only the costs of remedying pollution, but also those arising from the implementation of a policy of prevention. The polluter pays principle can be seen to be reflected in at least two situations in the courts: in sentencing for environmental crime and in making civil orders, including imposing pecuniary penalties and granting injunctive relief. Distinguished audience, coming to my conclusion, of course, all of us judges operate within territorial boundaries defined by rules of jurisdiction. Each jurisdiction has its own distinct history and culture, and its own constitutional or treaty arrangement and institutions. Courts cannot all of a sudden break away from their historic and domestic cultural foundations. At the same time, we cannot escape from the reality that certain areas and principles of law in fields such as environmental law operate across jurisdictions. Judges have in recent times recognized this reality and have come up with a very important initiative of establishing an institute known as the Global Judicial Institute on the Environment. The institute was launched in 2016 in Rio de Janeiro, Brazil, and has the mission of supporting the role of courts and tribunals in applying and enforcing environmental laws, in promoting the environmental rule of law. The institute is composed of actively sitting judges from around the world. It provides opportunities for collaboration, strengthening capacities, and provides research and analysis on topics important for environmental adjudications, court practices, and environmental rule of law. Distinguished audience, like most infrastructure projects, environmental rule of law requires continual maintenance, upkeep, and renovation. This applies to the ways in which the environmental rule of law is conceived, its comprehensibility, its practical effects, its adequacy to meet the purpose for which it was conceived. Working upon and within that infrastructure, observing and theorizing about it are legal academics, judges such as myself, legal practitioners, business community, and a great variety of other stakeholders. They represent diverse yet overlapping groups with a variety of occupational and organizational cultures, worldviews, and purposes, as well as methodologies. Let me conclude by saying that I firmly believe that this generation of students, with all its energy, questioning, new perspectives, and potential for innovation, is well placed to positively contribute to the growth of the jurisprudence of the environmental rule of law, and also to jealously guard the independence of the courts, which determine these cases. The ongoing efforts by the Symbiosis Law School to shape and improve the discourse on important subjects of law are impressive. It is a great endeavor you all undertake, and I take this opportunity to wish you well with it. Let me once again thank you for your attention, and I do look forward to any observations, questions, or any other views that you may have at this point in time.
Thank you very much, sir, for your insightful and expertly delivered lecture on the national principles of environmental law and rule of law, bringing practical aspects with various examples, not only from Africa and Europe, but also from India. Thank you very much, sir. We'll now move on to the discussion session, where we'll have Professor Raj Verma facilitating the question and answer session with the audience. So may I please invite Professor Raj Verma?
Yes, ma'am. Thank you so much. So the first question is that, do you believe that the establishment of an international environmental court with a global jurisdiction will be a step forward in establishing a universal environmental jurisprudence and at the same time ensuring that the sustainable development goals are followed and enforced?
Thank you for that question. I think the question, if I heard you well, there are some echoes, is, do I believe whether an establishment of a global environmental court will play an important role in ensuring that environmental rule of law is sustained and as well as whether the sustainable development goals can be achieved as a result of this environmental court? Well, I do believe that, and this is a question which has been debated over time, the concept of a global environmental court. It is a concept that I believe in, but the truth of the matter is we cannot achieve this in the very near future. It has been discussed over and over in the realm of international law, but due to the fact that in reality it has caused a lot of controversies, I don't believe we can achieve this in the near future. And that's why in the Global Judicial Institute on the Environment, we have decided to focus mostly on domestic jurisdictions, which deal with the day-to-day environmental cases. And we do believe that instead of concentrating our efforts on a dream which will probably not come to fruition, it's better that we bring together judges from different jurisdictions in international courts such as mine, in domestic courts worldwide, in order to give them a forum through the Institute to be able to discuss and exchange practices in order to be able to move forward in dealing with these cases of environment. And I can assure you that in the 4 years that the Global Judicial Institute on the Environment has been established, experiences have been exchanged, and you can see that it's leading to a more, I would say, harmonized way of domestic courts and international courts dealing with the question of environmental rule of law. And I do believe that this trend will continue if the Global Judicial Institute on the Environment is supported adequately. But as an idea, I totally agree with you that the global environmental court would play an important role in sustaining environmental rule of law.
Thank you, sir. So, as recently there's been some oil spill by the Japanese ship. So, yes. Is international law equipped to handle this huge impact on the marine ecosystem, and who can be held liable for this?
Can you repeat the question? There were some echoes when I...
So, recently there was an oil spill in Indian Ocean by a Japanese ship near Mauritius. So the question is, with regards to that, how is international law equipped to handle this huge impact on the marine ecosystem, and who can be held liable for this?
Yes. Yes, this is a very pertinent question in environmental law. Again, I should point out that international law generally has its own limits, because international law, as we all agree, is a body of law which comes into place when states negotiate agreements or maybe customary international law of certain practices, and opinio juris have evolved into customary international law. So the question is, in this issue of the spill of oil in Indian Ocean, is international law well equipped to handle the case? My view is that yes, it is. And I do believe that there's a customary international law principle, which is the principle of Can you hear me?
Yes, sir, we can hear you.
Okay, thank you. Yes. Which is the principle, the no harm principle. The no harm principle provides that the actions of one state should not be at the detriment of another state. It should not harm the environment of another state. This is a principle which has developed as a customary international law principle. So in itself, I do believe it's sufficient enough to handle this case. On the question on who should be liable, this is a question which I cannot answer up front because I've not looked at the details of the case. I need to look at the details of the case and see whether there's any state responsibility or state liability on any of these states which are involved in this spill. Was there an action or an inaction of the state involved? Those are the questions which international law will answer, and ultimately with a view of deciding who has the liability. But generally speaking, I do believe that international law, as it is today, is well equipped. Obviously, the next question to answer is which court can handle this case? as you may probably know, Prof, in order for cases to come before courts such as the International Court of Justice, there's always the question of jurisdiction. Have the countries involved granted or consented to the jurisdiction of the ICJ? Those are the questions which have to be answered. And again, this is a limit, because in order for the ICJ to have jurisdiction over disputes of given states, those states have to have consented to the jurisdiction of the ICJ, making it a bit more limited. And if you follow the jurisprudence of the International Court of Justice, quite a number of cases have not been entertained to because of lack of jurisdiction.
Yes, sir. Thank you so much. So could you? So the question is, lately there have been an increasing number of cases, such as the Juliana case in the US and the Uganda case in the Netherlands, dealing with climate change litigation. So the first part of the question is, do you believe organic environmental reform vis-a-vis climate change effects can occur via courts? And if yes, how? So that is the first question. So if there's a second question, if you would like, I'll speak the second question as well. Otherwise, you can answer the first question first.
Thank you very much. This is a very pertinent question. And this again leads to the reasoning behind the Global Judicial Institute on the Environment. We do believe that courts have an important role in forging the way forward for environmental protection, and especially in this case that you've expressed in the area of climate change. The Juliana and Uganda case are a case in point. These cases, the subject matter to this case is whether the states involved, that's the United States and the Netherlands, are doing enough in terms of their obligations towards ensuring that we minimize the effect of climate change. And as you can see, especially with the Uganda case, the Juliana case is still, I believe, ongoing. The Uganda case has gone all the way in the Netherlands to the Supreme Court. And the outcome of it is that the Netherlands has not fully complied to its obligations towards the reduction of carbon emitting activities which have an impact on climate change. And as you can see, this is a court-induced change in terms of the behavior of the country, in terms of the activities of the state. And this is why I do believe that let us, as people in academia, as judges ourselves, let us concentrate and put our efforts more on the already existing courts and how these courts can play their important role in ensuring that they positively impact on the protection of the environment, and especially in the area of climate change litigation.
Thank you, sir. So the next question on the comparative aspect. Do you think that environmental reform is more sustainable to enact and implement via political processes such as policies and legislations?
Part of the question, I think I missed it. There were some echoes.
Right, sir. It is a follow-up of the previous question itself of the Juliana case and the Uganda case. On the comparative aspect, do you think environmental reform is more sustainable to enact via political processes like legislations and policies?
Yes, I do think that political processes such as legislation are very important. As I pointed out at the beginning of my presentation, for us courts, we are at the tail end of any rule of law venture. We deal with cases that are brought to us, but we also have to deal with them in accordance with the laws in place. So the starting point should always be the legislation. Are we empowered as courts enough? Are we empowered enough to deal with the cases with the legislation that we have? That's why the political processes are extremely important. But let me point out that these political processes do not happen accidentally. There has to be all sorts of stakeholders who are supposed to be involved in order to push this political agenda and ensure that legislation is brought in place, which will ultimately ensure that courts have an enabling environment to deal with cases of environment or environmental rule of law, if you may. And when I'm talking about stakeholders, I'm thinking of stakeholders such as you distinguished professors in academia. Most of the times when you publish in this area, the political actors will wish to look at what you do, and you can always influence this political discourse on the question of environmental rule of law. Why am I saying this? And I've always told it to my fellow people in academia or professors here in Africa when I have an opportunity to speak to them. I've told them that the problem that we have, at least here in Africa, is that we always wait for the legislature to come up with laws, and then we critique the laws. But this should not be our only role as people in academia. We should be the ones moving the policy. We should anticipate what is happening in many more years to come and start forging that particular, start forging the way in dealing with a particular area by issuing policies or alternative policies. And I can assure you that when the legislatures or any other policymakers are in the process of making policies or legislation, they once in a while do look at what people in academia have done in order to support what they are going to propose. So this is my view on this. Yes, the political processes are important, but all the stakeholders should play their fair role.
So I think we can take in more. You had spoken about illegal poaching and exporting and trophy hunting in Africa. So the question is that, do you think a specialized tribunal for these matters will help and to hold criminals accountable?
Thank you very much. I really don't have an either or answer to this. Yes, specialized tribunals are very important in dealing with certain aspects, but at the same time, there comes a time when you specialize too much, you lose track of other important aspects of law. When we are dealing with the question of illegal trade in trophies and even more disturbing endangered species, when you're dealing with crimes, you are dealing with criminal offenses, maybe having a specialized court would lead to those judges being experts in this area, and maybe it will make it much more better. But at the same time, I also do believe that even where you have general criminal courts, the focus should be on training these judges to be able to deal with questions of evidence, because these are very pertinent issues when it comes to these crimes. Questions of how to deal with these cases. And we've seen that, and I can give you an example of here in Tanzania, where due to lack of expertise of judges in this area, a lot of cases go unpunished because of lack of expertise, not only of the judges, but also of the prosecutors and also of the police who are supposed to investigate these cases. So I do believe that we should concentrate rather more on on the human resource part of the people who deal with these cases, right from the investigating police to the prosecutors to the judges, and train as many judges as possible, rather than having a specialized court. I want to point it out to you that mostly the cases are lost even before they reach the courts, due to the way the investigations have been handled. So you may have a very good specialized court on the illegal trade of trophies and endangered species, but at the same time, it may not achieve the intended outcome if the investigation does not take place in a proper way.
Thank you very much, sir, for answering all the questions of the students. I would now, on behalf of Symbiosis Law School, Pune, extend my gratitude to Justice Emmanuel Ugirashebuja for your valuable time, for sharing your expertise and insight into international environmental concerns with our students. We hope that we have many more such occasions to collaborate and learn from you in the future. We are grateful to our visionary leader, Dr. Shashikala Gurpur, for her tenacity and excellence in ensuring legal education and exposing both our faculty and students to international standards of education. Thank you very much, ma'am. I thank the organizers of the program, Professor Sujata Arya, along with the International Cell, Professor Raj Verma for facilitating the discussion, and the IT team for their consistent support and guidance. Last but not the least, I thank all the students who participated and made this program effective and successful. Thank you all very much.